some of your attention, I hope. Vic has served extensively as a mediator and as an advocate representing clients in numerous mediations and arbitrations over his 50-year career. In addition, he has led rule of law and related educational initiatives promoting judicial reform, ADR, and judicial case management in countries including Brazil, India, Liberia, Bulgaria, Croatia, Republic of Georgia, Turkey, and Malaysia, among other countries. Mr. Schachter has been honored as a California Lawyer Attorney of the Year for his services in judicial reform, rule of law, and mediation building. In October 2020, he received the Mediator of the Year award from the Mediation Society of San Francisco for his outstanding contributions to the field of mediations. So with that, Vic, let me invite you to give some closing remarks on the international experience. Thank you.
Thank you very much. Are you able to hear me okay? Excellent.
Yes, we can hear you.
Thank you so much for that very kind introduction. And I am aware that you're running considerably behind in time. I will try and be sensitive to that and keep my remarks a bit briefer than I originally had anticipated. First, my congratulations to all of you, the High Court Judiciary, obviously Professor Piracha as well too, and all of you who are supporting a very admirable effort in Pakistan with the many challenges you are facing with the backlog court system and otherwise to build a successful mediation program. And I compliment you on that effort and again offer you my congratulations. I have been involved in my foundation since 2012 on a voluntary basis to promote the development of these mediation centers around the world. And actually, by way of history, I'll mention briefly, I have, prior to doing this work, been a litigator for 50 years. And only later in that career did I take on mediation, representing clients, and ultimately doing mediation. I'm what you call, like a recovering alcoholic. I'm a recovering litigator, and have really become so enamored with the mediation process, both in person and online, as Colin has discussed with you as well too, that it has really become a passion in my work, in the work of our foundation. And I compliment you on your efforts to date to try and build successful centers. Most important, I have learned from working around the world how critical it is to design a system that works within the culture of your country. And when we go and are invited by a host country to come and develop these systems with them, to assess and develop, the key thing we want to do is not bring our preconceived notions of what works in the United States or elsewhere, but what will work within the culture in your organization, so that when we leave after we've done an assessment or we've coached and worked with you, that program will be sustainable because it fits within that particular culture. And what I thought I would do in the time that we have, because there's no one model that works for everybody, and clearly now, as has been pointed out with the explosive growth of online dispute resolution. And yes, there will be continuing live mediations, and in fact, we're seeing something of a resumption in countries which are getting a little bit beyond the pandemic and under some control. There's no one model, but there are certain lessons that I have learned over these 20 years or so that I've been doing this work that I want to share with you. And I'll briefly cover what I call the best practices for building a sustainable and successful program, many of which you are either implementing now or attempting to implement, and many of which, in my view, under your ADR Act of 2017, which really encourages the use of mediation, even though it's an underutilized statute in Pakistan. I think these practices will really work to reinforce the messages that the other eminent speakers of your program have already alluded to in one sense or another, but hopefully will reinforce some of these key concepts. First, it is critical to do a careful needs assessment. What kind of a program do you want? Is it mandatory or is it going to be voluntary? Is it going to be ODR or in person or a combination of the two? What kind of disputes are you going to handle? Some countries handle commercial disputes and family disputes. Others handle real estate disputes and employment disputes. Some start with a pilot program, which I've urged the people, the folks I've been working with in Pakistan and talked with about this, to start with a good pilot program, build a quality program first, rather than go large and become overwhelmed with the complexity of many problems. And do you want it to include pre-litigation disputes? That is before the filing of court filings, and also have it after the litigation has been filed. We in the United States have encouraged both, and most countries that have successful programs allowed for both. And these kinds of assessments are critical, so one does not want to rush in and set up that pilot program or build on those pilot programs before the needs have been properly identified. 2, stakeholder lineup. This is critical. There was just someone that spoke about a strike that they ran into with the lawyers. Well, I went through exactly that experience in 2005 in India. We did a beautiful job working with the judiciary, setting up a program. And the one mistake that we made, and boy did I ever learn from that lesson, is we failed to bring in the bar associations to help design the program, raise their concerns. And in a moment I'm going to speak about this, particularly their selfish and legitimate concern and fear that they are going to lose income. I don't know if you've talked about this in this program, but I will tell you, in every country that I go to, the biggest resistance we get is often the unspoken, if not spoken, fear of lawyers, understandably, in using mediation and fearing that they're going to lose their litigation income. So these are areas that need to be addressed in advance, and the lawyers, and particularly the bar associations, need to be brought into that dialogue, and it needs to be explained to them how you can profitably run a mediation practice within your litigation practice, which is what we've learned in the United States and we've learned in other parts of the world. And I will tell you, one of the greatest myths of the many myths that exist about mediation ADR is that if I allow this in my law firm to go forward, I am going to lose income. That's not the way it works when there's a quality program. And if you have questions in this area that we have time to raise, I'll be happy to discuss that a little bit more. So making sure that the bar is behind us, making sure the judges themselves, in my experience, are often reluctant to refer to mediation programs. Why? They fear a loss of control. They don't necessarily know how to do an efficient referral. That's really important that the judges be trained on how to do a referral. I have a training program in which I do what I call a 6-minute referral, a quality referral that sets the parties up with the proper attitude to go into the mediation. So the judges need to be brought into the process, obviously, as well as the bar and the parties themselves. Third element, quality mediators and a quality mediation process. Here it's really important to make sure that you're providing a program, and this is why it's important not to get too broad and too many programs too quickly. It's important to have the lawyers experience a quality process at the beginning. I will tell you, in one Eastern European country that I worked in, they finally got the law firms in that country to refer the cases. But because the mediators had been given 40 hours of training, but had not been coached and not been given the support with experienced mediators on how to mediate cases, the first few cases that came to the mediation center were very, very unsatisfactory for the lawyers, their law firms, and their clients, and that brought us 10 steps back. So I want to emphasize to you that making sure that there's a process in place, that the mediators are appropriately trained and coached, and the systems are set up, is a very important third element that I want to emphasize for you. 4, good governance infrastructure. Some countries, there's oversight by the bar, oversight by the courts, oversight by mediators, and the best model, frankly, that I have seen globally has been a hybrid that invites the bar, invites high court justices, and invites, if you will, the lawyers, or the people from the bar associations, as well as the mediators, to be a group together that will be the oversight for the quality, handle complaints, and also will evolve to improve the system over time. So good governance and infrastructure is terribly important to make sure that the program from the beginning continues to develop and improve over time. 5, proper training of judges on referral and training of lawyers on how to represent clients in mediation. I've already alluded, and for the sake of time, I will not expand on this unless we have questions, how important it is to train the judges. One of the most enjoyable parts of my work as a volunteer over these 20 years is actually to go to judicial academies in the various countries and train the judges on the value of mediation and then what the techniques are referral, and then actually have them make the referral in front of the other judges in a healthy environment so they feel comfortable on the techniques of doing that, particularly when they're reluctant to do it because they are so pressed in court to take the time to make a proper referral. So that becomes really important for a quality program. And secondly, and most important in that regard, is the training of lawyers on how to represent clients in mediation. I will just share with you an anecdote. When I first started representing clients in mediation, I went in there and like a true trained adversary in litigation, I beat up the other side representing my client. I wanted my client to know that I was going to go in there and show how ridiculous the plaintiff was. And there was no merit to their claim. And I kind of pounded on the table. And I was so proud of myself. And I completely undermined the mediation process because I did not understand that we were there not to convince the other side that they were wrong and we were right. We were not there to litigate ultimately legal rights. We were there to collaborate with one another, to get beyond right and wrong, and to focus together on a voluntary resolution that will work for everybody. So it's really important. I've learned from my own experience, and in every country I've worked, the lawyers need to be trained on the advocacy skills, which are unique and different from litigation adversarial skills, on how to work in a collaborative way and use the mediator to reach a resolution. Number 6, professional administration of mediation center and case management. I see that Colin and others have talked already about a number of aspects of data management and overall management of the process, and I suspect your other speakers have too. But it's really important that when they come to that mediation center, that the parties feel welcome. And I can tell you in India, for example, when I started there in 2005, with very limited resources and very limited administration, we really worked to make people feel welcome when they came into the center and explain the process. And in fact, one of the techniques we used in answer to one of your early questions is we actually had set up a video. So while people waited, we had a little mock mediation that their lawyers and clients could see if they waited 15 or 20 minutes. And were able then to become better educated about the process. This is one of the ways that we educated the parties in a very effective way. In one state, they actually put a TV program on. It was a soap opera, and it was a mediation experience. And it was one of the most popular, actually, one of the most popular local TV programs to help educate the public about what's going on. So the whole administration of the center and case management is clearly a key element. Number 7, quality continuing education and coaching. I alluded to this before. After your mediators are trained, it is critical to give them coaching. That is to have experienced mediators sit with them and see what they're doing and give them feedback. Give them the opportunity to observe experienced mediators and then work with them. We've set up, through my foundation in the various countries that we've worked, one-to-one relationships with various of our board members to coach mediators around the world on a one-to-one basis on request to give them that support as they face their challenges. And in fact, we've set up what are called reflective mediation sessions in Brazil and India, 10 months of 2-hour sessions in which the mediators can come and talk about their challenges, and we work in a very supportive environment with them to help improve their skills. So this is a continuing coaching and educational process which maintains the quality in your organization. Number 8, effective feedback and program evaluation. It is critical, and I don't know if you have this in place already in Pakistan, give out written evaluations that are given to the parties and to their lawyers. Let them give you constructive feedback, which is provided on a confidential basis to each of the mediators, so they can see how they are perceived as well as how they perceive themselves. And also the mediation center can get feedback on what's working and what's not working. And similarly, feedback to the judges on their referrals. We take a look, we set up data on what judges are able to successfully make referrals that actually get to the mediation center, which are the ones that are not been suitably referred, so we can speak to those judges on an individual, constructive, or respectful basis to make them better in making referrals. So we urge that there be written evaluations and communication on a confidential, respectful basis with the participants. Number 9, full accountability for quality results, reliable and accurate data management. I know that Colin already spoke to that a bit. I won't expand on it other than to say it is absolutely critical to maintain good records. That is the way when we go in and we're invited back by host countries to evaluate the success or the needs of a program, we want the data. How many referrals? What judges made the referrals? Which ones got into the process? Which ones were settled and not settled? What kinds of cases were settled? And by the way, let me mention just tangentially, it's not always the mediator that has the highest rate of settlement. That's the best mediator. Oftentimes, it's the mediator that needs more and more sessions that really works using the skills of a mediator to work with the parties over multiple sessions to reach a resolution with a lower number of cases. And it can be a mediator that bangs out the settlements, but doesn't really engage in active listening and know how to get beyond impasse so the parties enter into a voluntary settlement. These can be shortcomings. So we look behind the quantitative results to the quality of the experience with the evaluations and the interviews and the meeting with the administrators in the process. So lastly, I will mention number 10, quality physical facilities and meeting structure. In one opportunity that I had in Africa, we were invited to come and work there, and then the setup for the mediations that took place then in person was in a very noisy area, lots of street noise, lots of noise around actually the courthouse going on, and there wasn't a place for the parties to be able to speak in confidence, quietly, in private caucus, much less in a joint caucus. And that really, of course, undermined the in-person experience. And I would say with respect to online dispute resolution, similarly, you want to eliminate that noise. You want to know, as Colin pointed out, how to use those chat rooms, how to set it up where you need. I use a hybrid often, where I use the chat rooms on Zoom, but I also get the mobile numbers of every one of the parties, and I will call them personally on the phone, on the cell phone, where I really want to have a dialogue that's apart, if you will, from the Zoom conference, and I find it to be very effective. Using all these tools in the toolkit to assure that the physical facilities, or if you will, the virtual facilities, are working for your benefit. So there's a lot more I would love to comment on. There's so many things that I've learned, mostly learned from the various people I've had the joy and the privilege to work with around the world. They have taught me so much on what is necessary to build a successful program. It's indeed been a privilege to do this work. And I want to leave you with the following theme, which is one never gives up. You must be resilient in working to build these programs. And I will say for Professor Paracha and all the others, and also the High Court Justices I've had the privilege to talk to, my kudos to all of you for your tenacity with the many challenges you have in your system. But that tenacity, that perseverance will lead to a very successful effort. And if you use the ADR Act of 2017 and all the other good suggestions and initiatives that you have right now going forward, I believe that you can have a very successful, well-scaled throughout the country. In a place like India, we've got 32 million cases backlog. In Brazil, a quarter of the population of India, 85 million cases backlog. And we have programs running through their centers and programs that we've been involved with that are just doing gangbusters. They are really growing and developing. You must overcome the resistance of the lawyers, get the law firms really to buy into it. If you want, if there's time, I can talk to you about some of the incentives that we build into the law firms for profitability. All of this will work to your benefit. So out of sensitivity to your time, I will stop here. And if there is time for a question or two, that would be great. If not, I understand that time has been quite tight. I thank you again for the opportunity to speak with you.